Yes, Mr. Wood.
Now, I promised before the luncheon adjournment, I think, in answer to a question, to find the answer to the issue about the reporting of two component particles and the circumstances in which that can be achieved. And I hope I found the answer to that. It's contained in the SWGGSR report and is identified by Ms. Shaw at page 16 in her latest report. Lord, if one goes to the SWGGSR report at page 3894, what becomes clear is that there are particular kinds of ammunition that do not produce three-component particles. And therefore, it may become necessary to report two-component particles because, and this is identified at page 3894 of the SWGGSR guide, and it's identified at page 19 of the report 3894 those kinds of ammunition that do, and other items over the page at page 20. And Ms. Shaw has dealt with this at page 16 of the small bundle in her latest report, where she cites that guidance, my Lord. Not all particles formed as a result of detonation of synoxide-type primers are characteristic lead-antimony barium composition. Particles containing one or a combination of two of the three elements can also form. In addition, many non-synoxide primers based on lead styphnate and other lead compounds do not contain any antimony sulfate or barium nitrate. Furthermore, some lead-free ammunition contains barium nitrate and antimony sulfate. As such, ammunition containing these types of primer will not generate characteristic lead, barium, antimony particles. The guide then lists the type of particles consistent with GSR that can be found from these types of ammunition. And that, my Lord, is done at page 3895, and I'm told it's also available in the more recent guidance. If any of the particles were found on a suspect in the absence of characteristic GSR, a sample from the firearm or spent ammunition used in the crime would be required to determine if the elemental composition of the detonated primer was similar to the composition of the particles consistent with GSR. And my Lord, it's in those kinds of circumstances and why we formulate the submission as we do as to two-component particles that, other than that kind of situation, we say such particles could not be and should not be admitted.
Now, that last sentence, Mr. Wood, which is Miss Shaw, only then could any conclusions, etc., is that derived directly in that language from the SWG report?
I do not believe so, my Lord. No. But there is further guidance, isn't there, on this topic, and it's where?
I mean, I can quite see that you need to know about this, because if you've got a reasonable possibility that it may be ammunition which has only got two components in it, you can elevate the importance of the two component particles that you find, obviously. But you're using it for a quite different proposition, which is that it is only then that you can use it.
But, my Lord, that's why it's necessary that the guidance contains this caveat about two.
Right.
Yes, okay, I'm being told that the guidance that makes this express is the FSS reporting guide and the Eurofins reporting guide. But, my Lord, we don't have those documents before us.
Okay.
And therefore, I deal with what I have. But I hope, my Lord, that fits with our submission to some extent at this particular stage, because, of course, our submission here is that the learned trial judge should have excluded the 2 and 1 component in the particular case, unless it could be explained to him why it would have some relevance. My Lord, I was dealing with paragraph 610 of our submissions upon that issue. And was at page 3356. Coming to what is also an important submission, that we say there was an overinflation of significance of 1 and 2 component particles by Miss Murtha during the course of her evidence. She said that an average person would not be expected to have GSR particles on them. My Lord, if your Lordship pauses for a moment, I will bring that up.
She did, certainly so.
At R1992 and 1992 to 1993. And it's during her her examination in chief by Mr. Byrne, and we say what she actually says is wholly shown to be wrong. I should have, he says, have asked you this earlier, but are there any studies you know of that look into whether or not GSR is found on ordinary members of the public? She responds on ordinary members of the public. Members of the public, he says, depending on a person's occupation. And she's obviously now referring to those of which we became aware earlier in 2007. There are published reports that indicate the average person walking down the street wouldn't have 3 component particles on them. So far, so good. And then she said, nor 1 or 2 component particles as well.
That is as well.
As well.
With 3 components.
That wasn't how it was interpreted. And it's certainly not how, and your Lordship may be right, but certainly it's not in our submission how it has been interpreted, and not how it was interpreted by the trial judge.
Well, if you read on, it's not entirely clear that that's what Miss Murtha was saying.
What do you mean by that? If a person is a hunter, for example, I wouldn't be unusual for me that I would see a certain amount of gunshot residue particles present. Well, that's to state the obvious. But, my Lord, the nor 1 or 2 component particles as well is what we certainly rely upon. She gave no scientific basis for saying this and produced no evidence in support. And the statement we've submitted was reckless with this implication, and it's now being dealt with and effectively demonstrated, we say, to be false by Ms. Shaw's second report, which deals with the background findings.
Has anybody anywhere done a decent scientific survey of, and I mean large numbers of people, I don't just mean a few prisoners in a particular American institution, but has anybody done a decent survey of large numbers of people wandering the streets
I
at
know
large?
that different
I don't know, I'm not sure whether it would even be possible, but has it ever been done?
I think various attempts in various jurisdictions have been made in relation to this. What's the answer? What? Yes, I'm told that the European Forensic Science Institute has done such a survey. And can you give me the name of it? Oh, well, there you are, my lord. It is a prevalence study from 2018. 2018.
In America?
It's a European. It's a European. It's a European prevalence study in 2008, and its findings for. Yes, the picture, I'm being told, painted, is the same as the specific material that you have from Bermuda, as disclosed by the report. My lord, one of the things I'm going to say this is that your lordship's raised concern about whether this was dealt with before. My lord, the funding for this kind of thing and these kinds of exercises is really difficult, but actually crucial to this kind of, and the steps that have been taken by us in order to ensure that this work was able to be done since my instructing solicitors became involved in this particular case to see whether, and to get to the bottom of the reality of this has been significantly complicated by the funding issues involved, and your lordship will see that there was a good deal of time after the swabs or the stubs had been taken before they were analysed, and that was completely because of a funding issue so far as it was concerned, and it was eventually done on my instruction after a conference in March of last year. And so, my lord, what one can see, although people were trying to do it, it's been very difficult to achieve it. My lord, I want to stay with paragraph 610. We say that that was one example of that which I've dealt with. And I now want to move on to the fact that the impression that the particles reported by Miss Merthyr are likely to be GSR. She gave, we suggest...
I'm sorry to interrupt you, Mr. Wood. I'm conscious that you haven't got all that long before the end of your time, and I'm hoping we're going to get something from you on ground two.
Yes, well, in fact, why don't I take the exceptional step of effectively inviting, as I did at the outset, your lordships to follow the links so far as they are, and the detailed submissions that are made on paper to establish the propositions that we put so far as the case is concerned, so far as the balance of that ground is concerned.
Yes.
In which case, my lord...
It's not exceptional, Mr. Wood. Time intervenes.
My lord, our ground two, the appellant's ground two, is that having admitted the GSR evidence, the judge treated that evidence, the way he treated it, caused significant difficulty. My lord, first, his directions were incautious, did not reflect the expert evidence that had actually been given, and instead they inflated the probative value. And second, his directions were, we say, unbalanced and unfair when read in the totality. My lord, we say that confusion is one that is clear if one actually looks, the one that has arisen in the Court of Appeals judgment, even in the 3 paragraphs in which at page 501 of the bundle, and I don't need to take your lordships to it, that effectively he's talking about the whole thing being smattered with GSR and the putting of the 2 and 1 component particles all under the GSR head led to a misunderstanding as to the scale of the smattering by the Court of Appeal. It's respectfully submitted that the Court of Appeal's opinion stemmed from the court's own lack of appreciation, no doubt based upon the trial judge's summing up, of the limited probative value of one component and two component particles, as set out in our earlier ground one. My Lord, the judge's directions, we say, at paragraph 7.4, inflated the value of the particular evidence so far as our client is concerned. And my Lord, can I then take you to paragraph 7.5 of the, where I'm going to invite you to go to the references, paragraph 7.5. The jury were wrongly and repeatedly told by the judge that the multitudinous implicating particulate had been found on the appellant's person and possessions. My Lord, at page 214 of the judgment, between lines 15 and 24, the trial judge said this: the prosecution is asking what in the world would make these two persons so unfortunate that both of these cycles have this kind of particles on both. Is it the environment, he asks dismissively? Is it a fireworks display? Were they both dealing in batteries? Or these other sources that I have already referred to? Is it more consistent with that? Or is it consistent with two men who went out on a shooting that night? My Lord, if one then moves forward 3 pages to 2117, having summarised what was on my client's hand and also summarised some of the evidence concerning the particulate, he said this: so here the prosecution has come again. This is at line 7 of page 217. 2 bikes, particles, grip, handle grip, passenger grip, 2 phones, particles, 2 hands, each man, 4 hands, particles. The prosecution is saying this, that these gentlemen are getting very unlucky that this kind of stuff is happening all the time. My Lord, so far as my client was concerned, that was a direction that will inevitably have led to the jury giving a wholly artificial and heightened value to what was wholly neutral evidence so far as what was on my client's clothing was concerned. My Lord, the next reference, 289, towards the end of he deals again. Is that evidence a defense designed? This is trying to diminish what was being said through my client's mother's evidence, to separate Mr. Hewey from the black shirt, WB2, Exhibit 1, found on the chair back in Mr. Hewey's room, knowing that it was on implicated particles, but not any DNA. Is it a defence designed to separate Hewey from that red and grey jacket? This is about him wearing the evidence that his mother gave, that he'd been wearing a white T-shirt, the DNA and the implicator particles. Well, again, our submission is that was giving a wholly elevated interpretation to it all. As for the tracksuit with its red thread and pocket pieces, which seems to match his red and black theme, of course, it was being said that it was inconsistent with the description given of the rider of the motorbike, which we know contains incriminating particles. Well, it did not, in our respectful submission, his clothing, when this was not so. Miss Merthyr had stated that the most she could say about particles found on the appellant in his possessions was that they could have come from a firearm, or they could have come from some other source. And the probative value of those particles, we suggest, was therefore neutral. Furthermore, that is confirmed by Mr. White's evidence, and we've given some indication as to that. And also, we make the submission about the absence of any finding, so far as he is concerned, of three-component particles. The judge wrongly directed the jury that GSR particles on Mr. Dill was supportive of the fact particles on the appellant came from a firearm. We say that that was wrong. It was misconceived by the trial judge. He wrongly directed the jury that the 5 GSR particles found on Mr. Dill's clothing were supportive of an inference that the particles found on the appellant came from a firearm. That, my lord, let me just bring that up. Is at page 79. So you might think that one, just because 5 3-particle components are on one defendant and no 3 particles on the other, but they both have all these particles. In other words, what he's doing is he's combining that using the 1 and 2, the 3 2-component particles found on my client in order to try and link him in. But they both have all these particles, that the principle that the GSR expert speaks about, that is, that they were, where there are 3 3-component particles, the other evidence may be supporting evidence, may very well apply in that case in respect of both men. Well, my lord, that again, we say, is a clear error and misdirection. However, as we've stated before, support is only given to that proposition if the particles are part of the same population. And this is something that we've discussed about it, which is the population of the particulate sample. And you have there the evidence of Miss Shaw so far as that is concerned, but also what was said by Miss Merthyr so far as that is concerned. What's
the reference for that?
The reference is 2982, 12 to 25, and yes, 2928, and lines 12 to 25. So what they seem to be saying there is 1-component particles, when present with 2-component particles, can be of significance when interpreting the population. Do you agree with that statement, was her evidence? Yes, it says that when 3-component particles, characteristic particles, are found. Oh, that's Mr. White, I do apologise. Yes, and it's up at the top of the page. It's Mr. White saying this, the 2-component particles consistent and the 1-component particles are supporting. And then he goes on to identify that it's in relation to the sample. And I have taken your lordships already to the report from Miss Merthyr, the one that was added in which she refers to that relating to the sample. And that, my lords, is at... It's here.
791.
It's page 794 of the bundle.
So do any of the criticisms you make of the judge's summing up depend on any of the new evidence? Can they all be made on the basis of the evidence at trial?
They can be made on the basis of the evidence at the trial. Absolutely they can. But, my Lord, certainly so far as our submission about actually the wrongful admission of the material, those grounds we say that what is happening here is a wide-scale use of one component and two component particles. My Lord, I do invite your Lordships to examine the actual deposits you have so far as my client is concerned, and the schedule that I hope you will be given will have with it references so that you can cross-relate the actual schedules of the particulate that is being examined and what is being taken from it. My Lord, they are in the bundle at my Lord, they are at page 3264, starting at page 3266 of the bundle. And it's worth looking up just one example of this stubbing analysis to see. Your Lordship's schedule will have reference to these documents, and they relate each to different items. So, for example, the first 4 pages relate to my client's hands and the samples from my client's hands, and one can see that he has a good deal of gold on them and some barium sulfate and the like. When one gets to particles like on the bike, one can see that there was 3 single particles of antimony and 4 of barium, but there was 159 particles of rich lead and other items coming, including 105 particles of gold. And, my Lord, I simply draw that to your Lordship's attention so that you can understand the very large numbers of particles being detected by this machine. Some of those particles were isolated and rejected by Miss Murtha and led in terms to we say an impression by the trial judge that there was something very selective about the particles which had been led in evidence, and it does not do so because actually there can be two-tone particles, as it were, that have a different spherical that get rejected in any event, but are equally, those that are rejected are consistent with items. Now, my Lord, I go to paragraph 7.6, where I was at, dealing with the wrong directions to the trial judge. Paragraph 7.7, there are the references to the words that the trial judge used, such as powdered and infested. And the like, so far as that is concerned, again, misdirections that would have led the jury to come to a wholly wrong and misunderstood approach to this evidence. He wrongly directed that the variety of particles found pointed to the use of a firearm. He did so at page 208. If you again give me a moment. Sorry. Oh yes, I've taken your lordships to the passage about the fireworks and the like, and the lack of good luck with it, again, I take your lordship to page 241. Yes, where he talks about there's no evidence of any paints or fireworks, etc., associated with these items, though there is evidence that Mr. Dill did work in the certain soil. This is at page 241 of the summing up. No evidence of what Mr. Dill did, I think. His brother worked in Maui, but no evidence of what he did. No evidence that either was involved in any previous shootings or was in proximity of any such shootings. In fact, Mr. Dill denies that that ever occurred. He said he's never been anywhere near any firearms or any shootings. And the prosecution, you may think, is entitled to say there is no credible evidence that either came into contact with such particles that they could have been deposited in such varieties and in such multiplicities of places, the places they were found. When all this is added to the rest of the evidence, including the discredited interview given by Mr. Dill, you might think that the prosecution is saying the incredibility of Mr. Kofi Dill, proved by the video of him, and the other evidence, you may think it is the prosecution entitled to ask that your verdict be guilty. And that was the way he concluded. He concluded his directions in connection with Mr. White's evidence in chief, having been through the samples, before moving on to the evidence in cross-examination. My Lord, it gives the flavour of what was being inflated here and could not possibly amount, save by a misinterpretation and a misunderstanding of the evidence. My Lord, having taken you to that particular passage, which is perhaps the highlight of the complaints we make, I move, knowing the time, fast through paragraph 7.8, where we suggest the jury were wrongly directed that the variety of particles pointed
I think we'll have to read those to ourselves.
And I invite your lordships to read them for yourselves. Absolutely, my lord. I draw your lordship's attention to paragraph 7.12, where again there are references to the areas of the particulate in evidence. 7.14, and then there are areas at paragraph 7.15 where we say the judge failed to give any proper direction on contamination at all. And there was no sample, going to paragraph 7.17 of our case, no control samples, no evidence as to the background levels of particles again. And my lord, I simply draw those to your lordship's attention. My lord, I'm moving forward simply to effectively our response, my lord. We dealt with some of the matters raised by the respondents in their case, and I think perhaps it's best to say that a skeleton in response, which your lordships have admitted is best left till then, particularly in these circumstances. My lord, there is one additional ground of appeal, which we formulated, having been alerted to the development in the case of Trott. It was formulated by us more than anything else to safeguard the appellant's position as to a point that is arising more widely in Bermuda, to enable it to be taken. I don't propose to argue it before your lordships in any detail, other than to invite your lordships to say that it's a point that should be remitted back, should it to the Court of Appeal, because it is best placed there so far as what I'm going to call the jury point, the Trott jury ground, my lord. Having said that, I see the time. I'm going to just pause for a moment and ask whether there's anything key that you think I ought to ought to cover.
We won't take you as having abandoned any of your case, Mr. Short.
I'm hopeless at this business about timing, and I apologise to your lordships that both my electronic incompetence, I'm trying to move into a new era in terms of formulating submissions. I have no doubt that my learned friend, being younger than I, will be able to very smoothly operate his computer and achieve it. But, my lord, those are my submissions on behalf of this appellant.
Thank you very much indeed. Mr. Poole.
My lords, I'm grateful. My lords, I propose to respond and break the response down into 5 parts. The first part, I will make some general submissions on the gunshot residue and particle evidence, how it was relied on and presented by the prosecution, the extent it was challenged by the defence, and how it was summed up by the judge. Now, the purpose of those submissions, as well as setting the scene for grounds 1 and 2, it is to deal with what I say are 3 fallacies in the appellant's case. And if I just list them before, obviously, then dealing with them. The first is that the 5 gunshot residue particles found on Mr Dill should, the appellant says, effectively be disregarded when considering the case against him. The second, that the 5 gunshot residue particles found on Mr Dill did not make it any more likely that the particles found in respect of the appellant came from a firearm. And the third, that 1 component particles essentially have no evidentiary value unless accompanied by gunshot residue particles.
Sorry, the third one again?
Third one, that 1 component particles have no evidentiary value, the appellant says, unless accompanied by 3 component particles. The second part of the response will then address the first ground. I'll explain why we say the Court of Appeal was right to find that the judge couldn't be criticised for admitting the particle evidence, demonstrate why the particle evidence, we say, was plainly admissible, and it was for the jury to consider the weight to be given to it, taking into account all of the evidence in the case, including the gunshot residue particles on Mr Dill, and why we say Miss Shaw's evidence doesn't justify any departure from the Court of Appeal's conclusions. So at that stage, I'll address Miss Shaw's evidence and the fresh evidence point. Third part will address the appellant's second ground, why we say the particle evidence was not misrepresented or misunderstood or misused at trial as the appellant contends. And again, insofar as Miss Shaw's evidence touches on that, why what points she raises do not assist and shouldn't alter the conclusions reached by the Court of Appeal. Fourth, the proviso, and we do say this is an overwhelming case, so if there has been any misdirection, we say this is a case where this board should apply the proviso. And then fifth, and very briefly, deal with the last point my learned friend raised, which is the jury selection point, because there's a point of fact to just bring to your lordship's attention. So if I can then move to the gunshot residue particles found on Mr Dill and explain why I say they are important in 2 respects. Now, the first relates to the alibi defence and the second to the significance of the particles found in the appellant. So if you like, the first is a forensic point and the second is a more scientific point. So, relevant to alibi. The board will be very familiar, and I don't intend to go back over the classification of particles. You've been taken to the ASTM guide and the SWAG GSR guide. You've had the references to both given to you. The ASTM E1588 is the standard guide for the analysis of GSR. You have the 2017 version at 3866, and the classification of particles is set out on that page. You then have the 2020 guide at 3871, and again, the classification is set out there. And just to note, there's a slight difference in language, but in my submission, and I'll come on to deal with this in a moment, the meaning is identical. You also have the ASTM 3309, which is the standard guide, as Millen Fred says, on reporting on gunshot residue. That's at 3436. And then you have the SWAG GSR guide at 3876, and the classification is dealt with at 3891. One point that the board may not have been alerted to is there's some suggestion made by my learned friend that the SWAG GSR guide should be afforded less weight because it hasn't been updated as recently as the ASTM guide. If the board looks at the latest ASTM guide, which is the reporting guide, which is 2021, and look at that at 3436 in the bundle, you will see at paragraph 4.1, which is dealing with significance and use, this guide is designed to be used by forensic science service providers when using final reports. 4.2, this guide is intended to be used in conjunction with practice E1588, practice E620, which the board hasn't got, and the SWAG GSR guide. So effectively, when looking at the ASTM guides, they are to be, this ASTM guide is to be read with E1588 and the SWAG GSR guide. Now, in terms of classification of three-component particles, the guides speak with one voice, which is that these are particles that have compositions that are rarely found in particles from sources that are not gunshot residue. And now what that means in practice is that a gunshot residue expert at trial is able to opine that a three-component particle most likely came from the discharge of a firearm. And that's obviously to be contrasted with one and two-component particles, where all that can be said is that those particles could have come from the discharge of a firearm, but equally could have come from multiple other innocent sources. And as I'll show, that is precisely what happened in this case. As regards Mr. Dill, a total of 5 three-component particles were found on clothing he was said to be wearing on the night of the murder. And the easiest reference I can give is you've got the statement of facts and issues, and there was, I think, what my learned friends have done is behind their printed case, they have their own, as it were, version of the facts, which is unagreed. What is agreed is the statement of facts and issues, which your lordships have at 3312, and the relevant references to Mr. Dill and the particles found on him are paragraphs 2.50 and 2.51 of the SFI, which is page 3325. The gunshot residue particles were found on the sleeves and the front of a tracksuit top and in the pocket of a pair of jeans. And both gunshot residue experts at trials, that's Miss Merthyr for the prosecution and Mr. White for Mr. Dill, agreed that those particles came from the discharge of a firearm. If I can just give your lordships the references to the evidence. Miss Merthyr making that point is 2076, line 18, through to 2077, line 1. Mr. White saying the same is at 2856, lines 20 to 25. And then we see that point summed up by the judge at 233, lines 5 to 10, and 227 at line 25. Now, of course, that's not to say that Mr. Dill discharged a firearm, as he could have been in proximity to a discharged firearm, or the three-component particles found on him could have been a result of contamination. The jury were, in my submission, made well aware of the limitations of GSR or particle evidence following both the expert testimony and the judge's directions. And perhaps the best example of the judge's directions on this, namely that gunshot residue particles do not mean that a person fired or did not fire a firearm. You find that at 204, lines 5 to 14. And then over the page at 205, just invite the lordships just turn this part of the summing up. 205, lines 1 to 3, where the judge says, I think in short, what is being said here, look, GSR by itself doesn't say anything. All it says is, I'm GSR. whether the person has shot the firearm or not depends on all the circumstances. You have to take the GSR and add it to the other things to determine whether that person shot the GSR, shot the firearm or not. That's what it says. That's all it means. Now, in terms of the relevance of the particles found on Mr Dill to the issue of alibi, the prosecution relied on the 3 component particles found on Mr Dill, obviously as one strand in the rope of evidence that Mr Dill shot the deceased. The prosecution also relied on the 3 component particles found on Mr Dill as one strand in the rope of evidence that the appellant was with Mr Dill when he shot the deceased. Now, this is because both the appellant and Mr Dill's cases at trial were advanced on the basis that at the time of Mr Robinson's murder, they were together at the Mid-Atlantic Boat Club, and they remained together for the rest of the night. Mr Dill gave a police statement to that effect. He gave evidence at trial to that effect, albeit he didn't call any alibi witnesses. The appellant, as is his right, chose not to give evidence and called no witnesses. But critically, for present purposes, he did not challenge Mr Dill's account. So in the circumstances, evidence supporting the inference that Mr Dill had discharged a firearm on the night in question was highly relevant circumstantial evidence in the case against the appellant. Namely, whilst he was with Mr Dill discharged a firearm. And in my submission, the appellant is wrong to suggest otherwise and is wrong to downplay that aspect of the case when looking at the strength of the case against him. And I'll come back to this when looking at the proviso towards the end of my submissions. So that's the first relevant aspect of the 3 component particles found on Mr Dill. The second relates to the interrelationship between those particles and the particles found on the appellant. The appellant's contention to the board is that the 5 3-component particles found on Mr Dill do not make it any more likely that the particles found on the appellant came from a firearm. And that's because the appellants say for the first time before this board, it isn't appropriate to consider the 3 component particles found on Mr Dill together with the particles found on the appellant. And there are 2 points we make in response. First, this was not a point taken by the appellant at trial. And this is an important point to bear in mind when looking at the expert evidence at trial and how the jury were directed on the expert evidence. And moreover, I submit that the reason the point was not taken by the appellant at trial is because it wasn't a point open to the appellant on the evidence that was led at trial. Now, of course, he didn't have his own GSR expert, and when looking at the fresh evidence, we'll explore potentially why that wasn't. He effectively aligned himself with Mr Dill's GSR expert. That's the first point. The second point is, in my submission, I say the contention is just wrong. And that's because in the hypothetical scenario presented by the prosecution, namely that Mr Hewey and Mr Dill were riding pillion on a motorcycle when Mr Dill fired between 4 to 6 shots, in my submission, all of the particles found on the appellant and Mr Dill could properly be considered a population of particles for the purposes of assessing the likelihood that that population of particles was gunshot residue. And I'll make good that second submission by reference to...
You have to explain why that isn't circular, Mr Poole. Maybe not, but you're going to have to explain why not.
My Lord, yes, and on that second point, I will touch on the fresh evidence. Going back to the first point about how the case was put at trial, it's necessary to understand the expert GSR evidence and the defence position. Now, both experts at trial agreed that 1 and 2 component particles found in the presence of 3 component particles are relevant when you're interpreting a population of particles. And consequently, the likelihood that the entire population of particles is gunshot residue. that point, and you've been taken to Miss Murtha's trial report, which is a February 2013 report. That's at page 794. And the board may recall that the reason that report was produced was a result of a defence objection that it didn't understand, or Miss Murtha had not properly explained the relevance of 1 and 2 component particles. And so the prosecution were given leave to put in a further report from her, which before trial came the February 2013 report. And she makes this point that when you've got 1 and 2 component particles in the presence of 3 component particles, they're relevant in the interpretation of the population. Mr. White makes the same point at trial in cross-examination. That's at page 2927, line 9, through to 2929, line 22. And in fact, in that passage of cross-examination, Mr. White is taken to the SWAG GSR guide, and the relevant passage from that page, internal page 17 of that guide, which is 3892. And we know that the, and perhaps for present purposes, if we just turn up 3892, which is the SWAG GSR guide. Point is made, 1 component particles, when present in addition to particles that are characteristic of and or consistent with GSR, can be of significance in the interpretation of a population of particles and consequently the likelihood that the population is GSR. And the board will have noted already that the ASTM guide, that's E1588, the analysis guide, makes exactly the same point. That's page 3866. Paragraph 3.1.4 of that guide. And that's the 2017 version. The 2020 version makes exactly the same point again, but with a slight change in language. That's 3871, where they say single component particles, when present in addition to particles that are characteristic of or consistent with GSR, or both, these particles can be of use in the interpretation of a population of particles, and consequently likelihood that the population is GSR. Now, I'll come back to and or in a moment when addressing in a bit more detail the fresh evidence. But for present purposes, I'm dealing still with just 3 component particles found with 1 and 2 component particles. Now, Lord Stevens asked the question, is there a definition of population? And may, in fact, be my Lord Jones asked the question. There is no industry definition of what is meant by a population of particles. This, in my submission, is because it depends on the facts of each case and who or what the suspect or suspects are said to have been in contact with. And I'll return in a moment to what I submit can constitute a population of particles, but for the purposes of this first point about what was understood at trial, it is important to understand that the Crown's case, obviously, was that you have the appellant sitting on a motorbike. Therefore, particles found on the motorbike, prima facie, formed part of the population of particles. Mr. Dill was riding pillion, sat behind the appellant, i.e. in very close proximity to, most likely in contact with the appellant. Therefore, particles found on him also form part of the relevant population of particles. And I don't think the board has got photographs. There were photographs before the jury of the motorbike in question, and the board, we can probably provide you with them if it was of interest. It's a standard motorbike. In other words, what I mean by that, it is a single-seat motorbike. It doesn't have a second seat behind for a pillion passenger. That's the basis on which the evidence was presented at trial, namely with both experts regarding the relevant population as all the particles found on the appellant, Mr. Dill, and the motorbike. And we see that perhaps most clearly from the defence's cross-examination of Miss Murtha. If I could ask the board to look at 2075, lines 9 to 13. And perhaps picking it up slightly higher up the page. So Miss Murtha's been cross-examined about the samples that were tested by R.J. Lee. And she's asked at line 7, and you'll agree that there were practically no three-component particles found on that whole population. And it is quite clear in my submission what is being put to Miss Merthyr there by Defence Counsel is all of the samples analysed by R.J. Lee. In other words, the population she's being asked about are all samples. Those taken from Mr. Dill, his clothing, Mr. Hewey, his clothing, the motorbike. Now, of course, in a different hypothetical scenario, for example, where the alleged shooter and accomplice are said to have been standing apart from each other, a population of particles might very well be limited to those particles collected from each individual. There's not alleged to have been sufficient proximity or contact. That may be the hypothesis that's put to the jury to consider. You do get some assistance as to sort of proximity from the SWAG GSR guide, because at page, it's a electronic bundle 3953, there's a suggestion that a person standing within 3 feet to the side of a shooter may have GSR on their hands, whereas a person standing 10 feet or more to the side of a shooter typically do not have GSR on their hands. Obviously, the point there being that the scenario put forward by the Crown in this case is that the two defendants are extremely close in proximity. Certainly no suggestion that they would have been more than 10 feet apart.
So the population would include the residue, the particles on the victim as well?
The only reason I hesitate, my lord, is I'm not sure we've got photographs. Well, we've got photographs. Don't think the board have got them of the deceased. I don't know how far away from the shot was fired from the motorbike to the deceased. I couldn't, hand on heart, tell you whether it was within 10 feet or not. Was it? But yes, in theory, my lord, it could.
It's all the particles that come out of the gun in a plume, wherever they descend, on who they descend, on whatever surface they descend. Is that right?
My lord, that's my submission, and that is what is explained in the, we're calling it the R.J. Lee sort of supplemental report, but the latest report that was put in by R.J. Lee. And my submission is that whether or not a population of particles can include particles found on different items, different people, it's probably a matter for the jury, having heard evidence as to how the relevant samples were taken, expert evidence as to what conclusions can or cannot be drawn from the particle evidence, and then applying those considerations to the factual scenarios that are presented to them. Now, the appellant makes a point that when Miss Merthyr is giving her evidence, at one stage, she uses the word population to mean sample particles on a sample. And we see that, and I don't disagree with, as far as that point goes, it's 1982, 9 to 22. But one has to read the question and answer in context, because she is being asked specifically about the testing of a sample. So her reference at 1982, lines 9 to 22, has to be understood in my submission in that context, namely how particles would be analysed and interpreted on a single sample. So in summary on this first point...
Was the population issue really explored at trial?
No, because, as I say, the presentation of the expert evidence was that you are dealing here with a single population of particles that include particles on Dill, Hewey and the motorbike. And so it wasn't the appellant's case at trial that the gunshot residue on Mr Dill was irrelevant when determining the likelihood that particles on him were also gunshot residue. And in my submission, the judge cannot be criticised for summing up the case in the way that he did in light of the expert evidence. And a very good example of this point is the passage of the summing up that you've already been taken to by my learned friend. But my learned friend sort of stopped slightly short in my submission of, when the judge is giving directions on this. It's page 79 over to 80. And the judge, it starts really at 79:20, So you might think that one, just because 5 3-particle components are on one defendant, no 3 particles on the other, but they both have all these particles, that the principle that the GSR experts speak about, that is that there are three component particles, the other evidence may be supporting evidence, may very well apply in this case. Or you may go the other way. You may think, well, look, it's the guy that has the 3 particles, this man doesn't have any, so maybe he committed the crime with somebody else, and this fellow didn't have anything to do with it. Not only is that an example of a balanced summing up, but that is an example of a proper direction on the expert evidence. And the reference there to the principle that the GSR experts speak about at page 79, line 24, is the principle that I'm dealing with here, namely the relevance of 1 and 2 component particles when found with GSR particles. That is the principle that the judges...
That was put, as I recall, the evidence in a fairly generalised way. In principle, when you find it with 3 component particles that support it.
Yes.
Rather than related to the specific of this case.
My lord, it was the evidence of Miss Merthyr, the evidence of Mr. White, so the experts were at 1 on this. Yeah. It's entirely in line with the ASTM guide and the SWAG GSR guide, and there was no defence submission that you should effectively not consider the 3 component particles on Mr. Dill when interpreting a population of particles. But I accept, my lord, that
well, it seems to be the issue the judge is identifying here between the 2 ways of looking at it.
Well, no. What the judge is identifying here is not disputing the principle. The principle is whether 3 component particles found with 1 and 2 component particles are relevant in interpretation. He doesn't dispute that. What he's saying here is, but you might think that because Mr. Hewey has no 3 component particles on him, then he was not connected with the shooting incident. And that's a point that the defence obviously did make. The defence's point was, you've only found 1 and 2 on me. Had I been involved in this, given the plume of particles that can be emitted from a firearm, isn't it more likely that I would also be found with 3 component particles if I was involved in this shooting? And that's a point that was legitimately put by the defence and left to the jury to decide. And the jury obviously rejected that when finding both defendants guilty. Now, the second point I make about this, leaving aside how it was put at trial, because obviously the appellants are now saying through Miss Shaw, and we need to sort of understand really what Miss Shaw's evidence is on this, because it has, and no disrespect to her at all, but it has evolved. And if we look at her first report, so this is the 9th of April 2019 report, she's asked, and I can give you reference to it. It starts at 3392. But the specific question she's asked is 3405. And she's asked to basically opine on her interpretation of Mr. White's evidence at trial and what Mr. White would have meant when he said found with or found in addition to 3 component particles. And what Ms. Shaw says is that she...
Sorry, the page reference?
3405, my lord. 3405. This is Ms. Shaw's first report, so 3,405. And question 13 is asked, and it's at the bottom of the page. And she says, over the page, 3406, I presume what he meant is found on the same sample. Now the relevant passage of Mr. White's evidence is at 2927, starting at line 9, through to 2929, finishing at line 22. And this is the passage of his evidence where he's been cross-examined on the SWAG GSR guide. Now, the first point to note on Mr. White's evidence is nowhere does he say that 1 and 2 component particles must be found on the same sample as a 3 component particle for them to be of assistance in interpreting the likelihood that a population of particles is GSR. So there is no reasoned basis in my submission for Mr. Shaw to presume that is what he meant when you look at that passage of his evidence. But the second point is when you actually read it in context and you understand the questions being asked by reference to the SWAG GSR guide, it is quite clear in my submission that he's talking about interpreting a population of particles. He should therefore be understood as referring to 1 and 2 component particles being found with 3 component particles in a population of particles. Now, again, this comes back to the question of what is meant by population of particles. But what he is not saying is that it has to be particles found on the same sample. Now, Ms. Shaw, having, in my submission, wrongly interpreted Mr. White's evidence in the way she has, she then goes a step further and she suggests that, in fact, paragraph 3.1.4 of the ASTM guide, this is the analysis guide from 2017, is also referring to particles found on samples taken from the same item. And this is, you see, that's what she says in the middle of page 3. Paragraph, she's quoting from paragraph 3.14 of the ASTM guide, and the conclusion she draws from that is the one set out at 3406, right in the middle of the page. She says, the above refers to particles found on samples taken from the same item. Now, 2 points on that. The first is that is not what the ASTM guide says. The ASTM guide refers, and this is a point the board already has, the ASTM guide doesn't talk about items or samples, it talks about a population of particles. The second point is it wouldn't, in my submission, make sense to have a sort of hard rule that a population of particles can only mean particles on samples taken from the same item. I mean, take, for example, a shirt worn under a jacket. The starting point ought to be to consider particles found on both items collectively, to have regard to the particles found on both shirt and jacket as a population of particles. It's because both items are so closely connected such that the source of any particles is likely to be the same. I mean, that's the underlying rationale for this. Now, there may be circumstances that render that inappropriate, but provided the facts are fully explained to the jury, most cases ought to consider particles found on items found together. And in fact, when one looks at Ms. Shaw's, what she says earlier in her report, it is inconsistent with what she says at 3406 on this point. If you have a look at 3400, and she's asked at question 3, from the pictures provided from Miss Murtha's examinations, do you agree that the particles she's identified in them could have come from a firearm? And she says, it's possible they could have originated from a firearm, but in the absence of 3 component particles found on items related to Mr. Hewey, then it cannot be stated that they've originated from a firearm discharge. Now, clearly there, she is envisaging a population of particles comprising samples taken from various items related to Mr. Hewey. So, for example, his clothing, the motorcycle he was riding. And so, I mean, my learned friend has put forward his own definition of population of particles, which in my submission has no support by even Ms. Shaw. His definition is that population of particles means particles found on a single item. Well, there's no scientific support for that, and it's not, in fact, what Ms. Shaw even says when we come to look at her 4th report. But there's no reason why the starting point, when considering what a relevant population of particles is, ought to not include surfaces that the defendant has had contact with or was in close proximity to. And in this case, on the Crown's case, that would include Mr. Dill, Mr. Dill's clothing, the motorcycle. Now, insofar as necessary, we do rely on the supplemental report from R.J. Lee, And they deal with this point about population of particles. It's internal page 5 of their report. And it's the second and third paragraph.
Sorry, which report?
So this is, we're calling it the R.J. Lee supplemental report. So this is the one that came in on, I think it is, with the annexure, it's 26 pages. I'm afraid I haven't got the internal.
But it's in other words, you're looking at 5 of 6.
I'm looking at page 5 of 6, my lord, yes. And the second paragraph and third paragraph deals with the population of particles. And the point that's made here is the point I've just been making, which is that population of particles is case-specific. Particles on multiple samples taken from an individual or garments an individual is wearing could be considered a population of particles. Samples taken from surfaces close to an individual, which could include clothing or skin of others, might also be considered a population from a particular shooting event. Now, Ms Shaw has responded to what is said there, and this is, if I can call it, Ms Shaw's fourth report. And just dealing with this question of population of particles, she says at page 6 of that report, which is, I think it's big numbering, page 18 at the bottom, internal page 6.
Is this the latest report?
This is her latest report, my lord, yes. She says that the only circumstances in which all of the samples taken from the appellant, Mr Dill, could be considered one population, along with the motorbike, is if samples had been taken immediately after the gun was discharged at the scene. Now, I make 3 points in response to that. First, I note that that accepts the principle that a population of particles can comprise particles taken from samples from different items and different suspects. The second point to note is that neither the SWAG GSR guide or the ASTM guide make any reference to time constraints or time restraints in terms of what constitutes a population of particles. And the third point is really just understanding Ms Shaw's justification for her conclusion. Now, most certainly, if all samples are collected at, to use Ms Shaw's term, time zero, they could be obviously considered a population of particles. Now, after an elapsed time of 6 hours, particles that were on items at time zero could have been lost or transferred. Additionally, more particles could have been gained. However, it is still possible that the particles on all the items could be attributed to one particular event. And it's not the role, in my submission, of a GSR expert to say that the particles analysed did come from a particular event. It is still a possibility that they did and therefore could be considered one population. And again, I repeat the submission, it's something that it would be for the jury to decide, having heard the evidence as to how the samples were collected and the expert evidence as to how that could impact on particles being lost or particles added. And these are points that I submit Ms Shaw would be bound to have to accept had she given this evidence at trial and been cross-examined on it. And I suppose it also has to be borne in mind that, I mean, in no case that I can think of will samples ever be collected at time zero. All sampling is going to take place with varying degrees of delay. And here, with the exception of the 2 jackets, which were collected, I think, on the 4th of April, all other items being collected about 6 hours after, on the 1st of April. They were all collected within a few hours of the shooting. They were all taken from the same location, in or in the vicinity of the appellant's home. And these were all, the jury was aware of this because there was a lot of evidence led from the officers that were responsible for collecting the samples. And also both GSR experts were cross-examined about the sampling exercise that was carried out. And I do submit that a GSR expert expressing a view on a hypothetical scenario is not, as I think Ms Shaw suggested is, to presuppose that the Crown's case is right, or, as my learned friend put it in his reply, to put the cart before the horse. It's explaining the possible inferences that can be drawn from the particles in a certain hypothetical scenario, which is the role of the expert. And the jury would have had well in mind that the particle evidence on its own could not assist them in determining whether the events described by the prosecution had been proved. However, the particle evidence could assist the jury when viewed in the context of the evidence taken as a whole. So, I suppose taken shortly, I say there's no scientific in-principle objection to particles found on items said to have been in close proximity to one another being viewed as a population of particles. You just don't get that from the fresh evidence. And moreover, on the basis of the evidence that was presented at trial, the judge correctly directed the jury on the gunshot residue and the particle evidence. And nothing that Ms Shaw says justifies a contrary view in my submission. Move then to the third and final sort of fallacy in the appellant's case, which is to do with one component, the relevance of one component particles. And in making these submissions, I don't want to sort of elevate the importance of this point, because again, it wasn't necessary at trial to analyse whether one component particles acquired increased significance if found with two component particles, as distinct from being found with three component particles, because, for reasons I've just discussed, the case was not presented in that way. It is, though, necessary to address this point because it really goes to ground one and the admissibility, because the appellant's primary case is put very high. It is said that a single component particle should never be reported as potentially having originated from the discharge of a firearm and should never be admitted in a criminal trial. And the learned friend, right at the start of their printed case, paragraph 1.2, which is page 3339, they rely, as my learned friend did in his oral submissions, on ASTM guide E3309, which is the reporting guide. And I've already made the point that the reporting guide needs to be read alongside the analytical guide and also alongside the SWAG GSR guide. But the paragraph my learned friend relies on, paragraph 5.5.6, which is 3438, it's simply saying that no interpretations can be drawn from single component particles found in isolation. So, in other words, one component particles found in the absence of GSR and two component particles. And the reporting guide is not giving guidance on the analysis of GSR. That's set out in E1588. And the board's been taken to the language of E1588 and the identical language of the SWAG GSR guides. And they both talk about single component particles when found with three and or two component particles being relevant when determining the likelihood that the population of particles is GSR. So in my submission, just on the basis of the standard guides, one component particles do not have to be found with GSR in order to be potentially significant. And I think the board has the references, but the ASTM guide 3866, the revised guide, same meaning 3871, and the SWAG guide is 3892. And in the SWAG guide, it's not just the point about classification. If the board has a look at 3899, please, where the SWAG guide expands on interpretation and says a comprehensive analysis of the entire population of particles, sorry, reading from the bottom of 3899, is necessary to establish the probable origin of any potential GSR particles within that population. probability that the population of particles is GSR increases significantly with the number of particles characteristic of and consistent with GSR, as well as the presence and number of particles commonly associated with GSR. Now, the respondent and Ms Merthyr and Mr White at trial take no issue with the proposition that single component particles in isolation have little significance. However, when present, in addition to particles that are characteristic and or consistent, so 3 and or 2 component particles, they can be of significance. And although Ms Shaw has quoted from the ASTM guide and referred to the SWAG GSR guide, she's tellingly in my submission not opined on what is meant by and or in those guides. She would, though, we're told by my learned friend at the start of his submissions, if asked, would agree that it means or. Now, that's obviously the plain meaning of the language of those guides. But Ms Shaw does provide some assistance, if there was any doubt about that, because she quotes in her first report, 3407, from an Australian study into background levels of one component particles. And that, so under the heading 3407 background levels, the second paragraph of Ms Shaw's response, she says that the authors reported that in the absence of any 2 or 3 component particles, these particles would not be reported or considered in relation to GSR. So there one has another source, if necessary, making the point that it's 3 or 2 component particles. So in light of all of that, in my submission, it is simply impossible for the appellant to maintain a position that one component particles found in the present case with 2 component particles are of no significance. They are potentially significant when interpreting a population of particles.
And so what's the additional significance when you get 1 and 2 together?
Well, my lord, the significance is it's the fact that 2 component particles are more likely to have come from a firearm. That's not to say that they did. You can only ever say with a 2-component particle or 1-component particle that they could, but they are more likely to have because 2-component particles are less likely to have been a result from environmental contamination than 1-component particles. So if 1 component and 2-component particles are found together, it is likely that they share the same source. And if that source is more likely to be from firearm discharge, it increases the chance that 1-component particles also came from a firearm discharge. And that's the point that in the R.J. Lee supplemental report is made at the bottom. It's the bottom of internal page 4, where Miss Leneve and Miss Helsall quote from the ASTM E1588 guide.
What's the page number?
Sorry, so it's the internal page 4 of 6, which I think is probably will be page 4. And it's the quote at the bottom of the page is the quote from the ASTM guide, the revised version, which doesn't use and or, but uses or both. And then they say, in the case of Mr Hewey, 1-component particles were confirmed in the presence of 2 component particles, even though it still is... My lord, sorry. I'm
on page 4. We've got
Page 5.
It's little numbering at the top left, page 4 of 6.
Yes, got it.
Page 5.
Which is 5 of the index, just to help.
Oh, I'm sorry, my lord. And I was just reading from the last paragraph on that page. In the case of Mr Hewey, 1 component particles were confirmed in the presence of 2 component particles. Even though it still is not possible to say that these 1 component particles were definitely from the discharge of a firearm, the fact that they were confirmed in the presence of 2 component particles does indeed increase the likelihood that the population could be gunshot residue. This is because it makes the 1 component particles more likely to be from the source that created the 2 component particles, much like 2 component particles in the presence of characteristic particles increases the likelihood that these particles are from primary residue. 1 component particles in the presence of 2 component particles also increases the likelihood that these particles could be from primary residue. Again, however, it still cannot be said that 1 component particles, even in the presence of 2, are definitely GSR, but rather that they could be.
That's, whether it's right or not, is directly the reverse of what Ms Shaw is saying, isn't it?
My Lord, yes. But this is why I say what Ms Shaw hasn't done, which she would...
No, I understand why you say we should prefer one rather than the other, but it's very difficult to do on paper.
My Lord, yes, I mean, the short point is, yes, it is. And I suppose Ms Shaw has had, because this point has been certainly a live point for some time, and Ms Shaw has produced certainly her 4th report and has not dealt with this point about the language of the ASTM guide, the and/or, and the, I mean, it's there clearly then being stated, the revised guide from 2020, and Ms Shaw is specifically responding to this report from R.J. Lee. But I suppose more than that, I think Melinda Friend confirmed that if she was asked, she would accept that it is or. So at least we've got sort of that stage in the analysis that she accepts that. Yeah. And it's very difficult, once you've accepted that, to maintain a position that 1 component particles simply have no relevance and should never be admitted.
Right.
And even if her evidence was interpreted as saying, as she says in her first report, it would be contrary to best practice, because I think that's essentially how high she puts it in her first report, to collectively report particles found on Mr Dill and the appellant. Obviously, in the appellant's case, all of the samples containing 2 component particles also had single component particles. So you have the appellant's black shirt. There was a 2 component particle found on the front, 13 single component particles found on the front, and then 5 on the back. Left front trouser pockets, single 2 component particles found with 5 single component particles, and 39 single component particles found elsewhere on the trousers, and then the red and grey jacket. Again, 2 component particles found. Just on a point of clarification, and I don't want the board to...
Black shirt was relied upon, it was unquestioned.
Well, my Lord, yes, and your Lordship raises that point because I think you will have read footnote 1 of Melinda Friend's reply, where it is said in footnote 1 of the reply, it's unclear whether the prosecution were attributing the shirt to the appellant or not. Well, if I can just give you some references, I say that's not right. It was very clear that the black shirt on the prosecution's case was the appellant's, and that's certainly how everyone has understood that until...
Well, they asserted it.
Oh, absolutely. Oh, no, absolutely. Yes. Because in distinction to other items of clothing, he was linked by DNA to other items of clothing. The black shirt, there was no DNA link. But if I can just give you some references. So Miss Cole's evidence was that if asked, she would have said, in relation to the black shirt, which is Exhibit 11 WB2, she would have said it was the appellant's. That's 1444. When Miss Murtha was examined in chief about the shirt, it was in connection with Hewey. So effectively, the prosecution went through all the items linked to Hewey first, and this was one of them. That's 2169. Mr Dill wasn't cross-examined about it, as you'd expected he would have been, had it been said it was to do with him. And then in the summing up, the judge makes it very clear that the Crown's case was that the shirt was worn by the appellant. If I give you the references, 191, lines 7 to 10. Perhaps the clearest is at 237, lines 19 to 20, where the judge says the Crown is inviting the inference that this is Hewey's shirt. And as I say, it's always been understood up until Millen & Friends' reply that the shirt was the appellant's. There was also possibly, and it may be me, some confusion about the jackets right at the start of Millen & Friends' submissions. And again, I don't want the board to get the wrong end of the stick in this respect. There was what's been described by parties as a red and black jacket. That is WB 21. That was said to belong to Dill. There was a red and grey jacket, which was CDN 3/4. That was said to belong to Hewey. And I mean, the easiest place to take that from is the agreed Statement of Facts and Issues, paragraph 2.19, page 3318. But there's also, if necessary, references in the evidence. There was, in fact, DNA connecting the appellant to the red and grey jacket. And you see that at 2537.
And Dill's on the other jacket.
Absolutely. And you've got the reference, I think the reference to that is 1449 to 1450. Now, the reason I started this part of my submission saying I don't want to sort of elevate the importance of this is, as I said at the time, that this wasn't explored at trial, namely one component particles found in the absence of three component particles, because it was all viewed as a single population, including all three component particles. But the appellant is wrong to say that Miss Merthyr didn't give any evidence addressing this issue. And if one looks at 1982, lines 14 to 22, this is Miss Merthyr's evidence. She's giving an example of a sample there with 1 and 2 component particles on it. And her answer that she gives only makes sense if what is being said is that 1 component particles found with 2 component particles are relevant. And that's, lest there be any doubt about that, that is obviously her position, because she's made that position very clear in the R.J. Lee supplemental report. And that's how the judge obviously understood her evidence, because that is how he sums it up to the jury at 244, lines 12 to 25, where he says to the jury, when going through Miss Merthyr's evidence, you don't need a 3-component particle in order for single and 2-component particles to have significance when analysing a population of particles. Now, the appellant takes a point in his reply that when you look at the February 2013 report, Miss Merthyr's 2013 report for trial, it doesn't make the point about 1 and 2 component particles present without 3 component particles. And the relevant part of the report, you've got the report at 794. Now, the appellant is right. It doesn't make that point. But the reason it doesn't make that point in my submission is because there was no issue. She didn't need to address that point. In other words, it was taken as read that 1 and 2 component particles were found with 3 component particles for relevant purposes. But what she says in her February 2013 report and the evidence that she gave at trial doesn't negate the fact that a population of particles containing only 1 and 2 component particles have evidentiary value. And nor does anything she said in her report for trial say that a population of particles without the presence of GSR is not GSR. And the board will be aware that the jury had the benefit also hearing from Mr. White, not just Miss Merthyr, on this at trial. He was cross-examined on this. And the relevant parts of his cross-examination are, I think I've given you the references already, 2928 to 2930. So in my submission, and just in summary on this third That's a fallacy. I say the appellant is wrong to say that one component particles found in the present case had no significance, as they were found within a population of particles with both 2 and 3 component particles. Now, before moving to ground 1,
if I ask, I'm conscious of time, but since we've been asked to deal with it generally, do you want to say anything about the proposition, which I think is contained in various reports of Miss Shaw, that one, the Forensic Science Service, when it existed in this country, did not report, or had reached the point where it did not report single component particles, and secondly, Miss Helsel, I think, from R.J. Lee, said in the trial of Mr. Trott that that was now the RJL practice also. First of all, do you know whether what's said about the FSS, Forensic Science Service practice, is right? It hasn't existed since 2010, as far as I can remember. But...
Well, I don't know about what is said about the service is right. It is right that R.J. Lee no longer report on single component particles, and I think it's explained in the supplemental report that they make the point that that doesn't affect any prior testing or any expert testimony that R.J. Lee have given, provided that the significance of the single component particles is properly explained. And I mean, we
do say anything about why they're not doing it anymore, apart from the line in the trial of Trott there of is it limited? No. Yes, limited value.
Well, no, and I don't want to, as it were, sort of give evidence, but drawing together the threads and making a submission out of them, if I can, I think the answer is probably this: that in isolation, one component particles have little to no significance, and I've made that point, and that was a point that was accepted at trial by Miss Merthyr. So they would never be reported unless found together with 2 and/or 3 component particles. And moreover, one component particles aren't needed in a sample population in order for population 2 and 3 component particles to have value. So I think, and no doubt cost as well, but there's no evidence of that. But R.J. Lee therefore stopped analysing one component particles, I think in line with the majority of labs that analyse gunshot residue.
Thank you.
Before moving on to ground 1, if I can just give the board briefly some references to make good a point that runs through our response to a number of the points that are made by Melinda Friend, which is that by the time of their deliberations in my submission, the jury would have been left in no doubt, I say, that the particle evidence that was found on the appellant was inconclusive when viewed in isolation. But when viewed with the other evidence in the case, including particle evidence found on Mr. Dill, could support the inference that he was with Mr. Dill when he shot the deceased. Now, the starting point to make good that submission is the expert evidence that the jury heard. And just giving the board the references, we've set these out at paragraph 20 of our case, which the board will find at 3530 over the page to 3531. And perhaps I'm certainly not going to take the board through all of those references there, but draw specific attention to the passages at 2142 to 2143, where Miss Merthyr explained that both 1 and 2 component particles could come from multiple other sources than the discharge of a firearm. And she gave numerous examples, including wind-blown soil and dust. So following her evidence in my submission, the jury would have been left with the clear impression that her view was that it was not possible to deduce from the presence of 1 and 2 component particles found on the appellant's person and possessions whether or not they came from a firearm. And it was equally possible that they could have come from an innocent source, and the jury had listed before them numerous innocent sources that could explain the presence of 1 and 2 component particles. Mr. White's evidence was of a piece with Miss Merthyr on this, and we've given the board the references to his evidence of paragraph 22 of our case. It's 3531. And again, as I submit, the effect of his evidence was much the same, i.e. 3 component particles came from the discharge of a firearm in all likelihood, whereas all that could be said about 1 and 2 component particles were that they could have come from the discharge of a firearm, equally could have come from numerous other sources, including environmental contamination. And again, he listed a number of potential sources. And then the summing up, and I'll deal obviously when I get to ground 2 in specific detail with certain passages of the summing up, but just on this general point, I've listed at paragraph 24 of our case the references in the summing up that I submit, taken together, would have left the jury in no doubt of the significance of the particle evidence and the inferences that could properly be drawn from it. And for example, the judge repeatedly reminded the jury that all that could be said in respect of 1 and 2 component particles is that they could have come from the discharge of a firearm. And he said could and did are 2 very different things, and we see those directions at 202, lines 7 to 9, and 210, lines 19 to 23. And the judge repeatedly reminded the jury that 1 and 2 component particles could have come from a variety of innocent sources, including the environment. And we see...
If they only go to could, does a number of them matter?
No, my lord, the number, and I'll come on to this in a bit more detail when dealing with ground 2, the references to some multiplicity that you see in the judgment, I say is no more than reminding the jury of what the evidence was. And multiplicity, the number of particles, is relevant when looking at the fact that you have 3 component particles found with 2 component particles and 1 component particles. And the experts made it very clear that if you had 1 GSR particle or 100 GSR particles, it doesn't make it more likely that it is gunshot residue. Miss Merthyr gave that evidence. So the jury would have had well in mind that the number doesn't impact on the probability. The number is relevant to an interpretation of a population of particles, and we get that from the passage of the SWAG GSR guide I took you to, page 3899, where they say the probability that a population of particles is GSR increases significantly with the number of particles, the presence and number of particles associated or commonly associated with GSR. No, on the question of probability, no. And as I say, I'll give your lordship the...
Does variety matter either?
Variety matters if by variety what is meant, as I submit that is what was meant here, the variety being 3 component, 2 component, and 1 component.
I think it means within...
Sorry.
I think it means within one component particles, the different elements.
So the composition. Well, yes. Well, in that case, yes, my lord. The composition can matter, and this is again evidence that Miss Merthyr gave. So, for example, when you've got 2 component particles, you can eliminate a number of particles based on morphology and composition. And she gave evidence, and perhaps if I can give your lordship the reference to this now. So it's 1981, line 14 to 1982, line 5. And that's where Miss Merthyr gives evidence that she had gone through a process of elimination when she had reported on particles and had removed particles whose morphology and elemental composition was not consistent with gunshot residue.
Isn't that referring to a situation where, for example, there's a very high presence of iron, which would indicate that it's come from a different source, from breaks or whatever?
My lord, yes. What Miss Merthyr is saying there is she's not saying that the absence of these, if you like, these contrary markers make it more likely that the particles came from a gun rather than an innocent source. What she's saying there is that the correct morphology and the lack of, I think her language is tags, enabled her to say that a firearm was a possible source. So when she has reported on that population of particles, she is saying that firearm is a possible source. Because I think Ms Shaw takes issue with this evidence and effectively says that the impression that the jury would have been left with is that Ms Merthyr was saying that this increases the likelihood that the particles were from a gun rather than an innocent source. That's not what she's saying, and that's not, in my submission, on a fair reading of her evidence or how the jury would have understood it.
Really,
I think this is a different point, isn't it? I mean, as I understand the judge's direction, he was telling the jury that the fact that the single component particles are found to be barium and lead and antimony in itself is an indication that it's more likely to come from a discharge of a gun.
Well, if that is the interpretation of the judge's directions, then if what is meant there is that the population of particles that the jury is examining, then that would be right and in line with the submissions I've made, because it is the one component particles when viewed with two component particles and three component particles in an entire population that increases the likelihood that the entire population of particles is gunshot residue. So that would be an entirely proper direction to give, namely pointing out that the one component particles are one component of barium, antimony or lead, as opposed to iron or something.
But I don't understand it to relate to one, two, or three component particles. I understand the judge to be making a point in relation to one component particles. And secondly, I don't understand it to relate to the population, which is a distinct point. I understand it to be no more than the fact that the variety of elements found within the one component particles is of itself a matter which can be relied upon as indicating a greater likelihood that the source is a discharge. I mean, that's how I read his directions, and he says it a number of times. He says it at 210, he says it again at 241, I think.
My lord, with respect, that's not how I read the judge's directions, and when I'm addressing ground two, I'll make some further submissions on this. But given the reason I say it's not how I read the directions, it is in context of how the case was being put, because if the case was being put that you have to look at everything separately, you don't look at a single population of particles, then I can understand your lordship's interpretation of the judge's directions. But the judge here was directing the jury to look at all the particles in the round in line with what I say is entirely proper when looking and interpreting a population of particles by reference to the fact that you have one, two, and three component particles. It's a point also that the Court of Appeal made, because they say the judge was entirely proper to look at the variety of particles. And in my submission, what the Court of Appeal is talking about there is the entire population of particles, and perhaps going to the Court of Appeal's judgment, that is, in my submission, clear from the fact. So it's page 501, page 36, sorry, paragraphs 36 and 37. So they make the point at 36. In our judgment, the judge was correct to admit the evidence because it had to be considered in the context of the other evidence in the case, not least the evidence both appellants were together on the night. Both bikes had particles on them. Dill's jacket and jeans had 3, 2, and 1 component particles on them. presence of the 3 component particles was of particular significance in view of scientific evidence that they had come from the discharge of a firearm. Such evidence, in the absence of any evidence from Hewey, could assist the jury in weighing the significance of the 1 and 2 component particles found on Hewey's clothing. Further, the 2 and 1 component particles comprise between them the 3 elements necessary to constitute GSR, namely lead, barium, and antimony. And so I said what the Court of Appeal is looking at there is the population of particles, meaning all particles found on both Dill and Hewey and the motorcycle, and saying that the judge's directions were therefore correct on the expert evidence. And then they go on to make at 37 a separate point about describing the limitation of the GSR.
Thank you.
So the argument, sorry. Please.
I was merely thanking counsel.
Have I got it right then? You're saying, well, if found with 3 component or 2 component, the 1 component have some support. Question, what support? If they're of a mixture of the relevant elements, the relevant metals, that itself is not irrelevant. Is that what you're saying?
It is what I'm saying, my lord, and it goes to the point that I was trying to make when asked what's the relevance of finding 2 and 1 component particles. It's the fact that you start from the rationale is that they came from the same source, and so
they might have done,
of course. But that's the sort of rationale for why 1 component and 2 component particles are relevant in the interpretation of a population. And you, as it were,
I suppose to look at it in a different way, that if you had a 3 component particle or particles, and there weren't any 2 components or 1 components, then you might start to raise some questions, because they've all come from the same population. They should come from the same population. And I suppose if you had only 1 component of 1 type, then that might raise questions about the validity of the 3 components as well.
Well, yes, and I mean, I can do no better than agree with your lordship and quote what is said in the SWAG GSR guide, which is essentially that, which is that the probability that a population of particles is GSR increases significantly with number of particles, and then read on the absence of elements or levels of elements in detected particles that are not commonly found in GSR, the absence of accompanying particles characteristic, presence of morphologies that indicate. So it lists a whole number of factors that are of potential significance when determining whether a population of particles is GSR. And so variety, meaning chemical composition, is a relevant factor.
Can we just go back to tags and shape?
Yes.
Paul, if I've understood it correctly, what Miss Merthyr was saying was that she, as it were, weeded what was found and weeded out things which were excluded or likely to be excluded as gunshot, either by reason of shape or by the presence of a stray tag of something that suggested a different source. Iron is an example, but there are others as well. Yes?
Yes.
Okay. Now, is there any warrant for saying that because the particles that have survived the weeding haven't got the wrong shape or stray tags, it follows from that they're more likely to be from a gun?
That was not her evidence. I think
No,
the effect of her
I'm pretty
evidence,
sure it wasn't.
the effect of her evidence was that having performed that weeding out process, it enabled her to say that a firearm was a possible source. Had she not carried out that weeding out process, she would have had to caveat that.
Yeah. I'm afraid there's a follow-up, which is that at some stage, would you address the question of whether the judge left the jury with the impression that it did make it more likely?
Well, yes, and if I conveniently can do that underground too, and I'll deal a bit more specifically with the summing up and take it in context.
Mr. Poole, you referred us to 3899.
Yes, my lord.
And over the page to 3900. It's not clear to me which passage you rely on as supporting the proposition that the variety of components of particles is something which makes it more likely that it was from a discharge of a gun. I understand at the top of the second of those pages, the reference to the absence of elements or levels of elements in the detected particles that are not commonly found in GSR as relating to the elimination process of presence of other elements. It's a rather different point.
My lord, I was relying on the fact that here you're being told one of the factors is the presence and number of particles commonly associated with GSR, so that being one component particles. My lord, I accept that in the SWAG GSR guide there, they're not specifically dealing with a variety of composition. I would accept that.
Thank you very much.
I have difficulty with the line, the presence and number of particles commonly associated. And I thought the evidence at the trial was that the number was irrelevant.
My lord, yes, the number is irrelevant to the likelihood, the question of the likelihood of whether or not it's GSR. Yeah. And Miss Murtha's evidence, as I said, and I think Mr. White gave the same evidence, that you could have 1 or 100, it wouldn't make any difference, it wouldn't make it more likely that it was GSR.
And yet this passage says the probability that a population of particles is GSR increases significantly with the then jumping down the number of particles.
Well, I think the difference here is this is looking at the population of particles as opposed to a single particle. But I can see your lordship's point.
Or was the trial evidence about the weight to be attached to the presence of the three element components? I don't know.
My lord, I was going to move on to ground one, and I'm happy to make a start, but it is.
If you've got a couple of overarching points, by all means, Mr. Falls. Otherwise, we might make a fresh start.
Well, perhaps I can just leave you. I mean, in summary, on ground one, we say there's no basis for challenging the decision of the trial judge to admit the evidence. So that requires looking at the challenge that was made to the evidence at trial. And then secondly, we say neither does the new evidence provided by Ms. Shaw justify such a view. Obviously, I'll unpack those submissions and hopefully make them good in the morning.
Okay, thank you. You're on course, are you, within your allotted time?
My lord, yes. I think I've got until.
You've got quite a while.
12:30.
Yes, yes. Don't feel you have to take the whole of your.
My lord, don't.
We'll resume tomorrow at 10:30.